I'm Nate Eaton, and today I'm talking with David Leroy. He has decades of experience practicing law here in Idaho as a defense attorney. He's also the former lieutenant governor here in Idaho, and he has been an expert that we've turned to for a lot of issues with the Daybell case. So we know that in just a few days, jury selection begins in the Lori Vallow case. Can you just give me the basics? What does that mean?
Well, jury selection is that process by which a random set of citizens is called to the courthouse by the jury commissioner of a respective county and brought into a courtroom, seated in the back, and one by one, to a total of about 12 people or initially in a felony case. They're called to the front of the room by the judge as the judge's clerk randomly draws their name out of a box. Seated in that jury box, then the prosecution and the defense in turn get a chance to ask them questions in a process called voir dire, a French word meaning to see and to say. And the idea is to ask people questions about whether they can be fair and impartial and objective jurors in this case and decide the case only on the evidence they hear in the courtroom. In a highly publicized, highly controversial matter like this, there will be a certain number of people who've heard too much about the case, who've already made their mind up about guilt or innocence, and those people would be excused for cause. And then when we finally get down to 12 people or so, or in the case of a long trial as we have here, maybe 13 or 14, there'll be an alternate or two chosen as well. Then the judge will say to the lawyers, all right, you have an opportunity to exercise what are called peremptory challenges. You can arbitrarily decide that this juror might be less fair to your point of view on the case than another, and you can bump a certain number of people that way. To the extent that anybody is bumped by the prosecution or then by the defense or by the prosecution again as they go through those, then another person is called from the back of the courtroom to fill that vacant seat. We continue through that process until you get your 12 plus one or two alternates seated in the jury box. And then the judge declares the jury is seated. We have 12 people who are impartial in this case, can decide objectively between the two competing sides on the evidence heard here in the courtroom. That's jury selection.
What are things that the prosecution and the defense attorneys are looking for when they're questioning these jurors?
Well, from the point of view initially of have you made your mind up about the case, that's very problematic for either side or both sides, and those people would be excused by cause. They're also asking for people who have strongly held opinions about the criminal justice system. It works, it doesn't work. People who are perhaps related to law enforcement officers or who know any of the witnesses or parties in the case. Anybody who would have an admitted or an implied bias to be involved one way or another or not be fair to both sides in the case. The prosecutor's questions would ask, of course, do you understand about a reasonable doubt is not beyond all possible doubt? And the defense would ask, of course, do you understand that a reasonable doubt is a thing that if it exists in your mind, you must throw this case out? And back and forth they would go on those kinds of concepts. But while each side is looking for a fair and impartial juror, they're also looking for somebody who might tend to favor their particular point of view from an ethnic point of view, an elder point of view, a man or a woman point of view. Each of the lawyers and each of the teams of lawyers in this case will have an idea about those kinds of jurors that might more likely than not be inclined to be sympathetic to their evidence as they intend to present it. They're looking for those jurors, and some combination of the prosecutor's favorites and the defense favorites will ultimately be seated on the jury panel, though they would all acknowledge that they're objective to start.
And jury selection, I would imagine now, will be much shorter now that Judge BOISE has taken the death penalty off the table, right?
Absolutely. In the case of a death penalty case, so much of the inquiry is related to moral scruples, a person's feeling about whether they could ever sit in judgment of another human being, with the possible outcome of that being a vote for death or life. That would, I'm sure, now that that's off the table, make this jury selection more swift by 50, 60, 75%.
Speaking of the death penalty, a little divergent here. A lot of people were kind of surprised that the judge did take the death penalty off the table. He explained it in a 40-minute oral ruling. What were your thoughts? Were you surprised to see that the judge made this decision?
Well, of course, it was surprising, because usually death penalty issues are addressed after someone is found guilty, not before the case begins. I was not in the courtroom, did not hear the judge's expanded explanation. I haven't read anything that details it, but I suspect that the judge was faced with an unfortunate choice when the death penalty motion, the motion to remove the death penalty part of the case, was also coupled with a motion to preclude the introduction of evidence. That's called a motion in limine, a pretrial motion that designed to affect what evidence comes in at trial. Because the prosecutors, in the very last moments before the evidence disclosure deadline was cut off, dumped on the defense about 5,000 pages of material and about 30 hours of oral tape testimony or statements. I think the judge was concerned that we might, if this case were to go forward as a death penalty case, face a very strict scrutiny about whether the defense had a fair opportunity to look at all of that evidence. And I believe the judge thought he wanted all of that evidence, most of which probably had been previously disclosed to the defense, to be available to the prosecution, did not want to unfairly preclude the prosecution's presentation of evidence, but he did want to recognize that that was a late disclosure, perhaps disadvantaging the defense in some particulars, and in that regard sort of settled on a halfway approach, taking the death penalty off the table.
Okay, so the jury selected, they're seated. First thing that happens is opening arguments. Explain, what are opening arguments? How long do those take?
Opening arguments are slightly misnamed in that they're opening statements by each of the respective parties, should they choose to give them, that are designed to outline the evidence that the jury is about ready to hear. You're not supposed to argue, you're simply supposed to outline the evidence that the jury is likely to hear. The prosecution goes first, and typically they would give some idea of the elements of the case, those things that have to be proved. They would give some list of the evidence that will be involved, probably explain what kinds of witnesses and then perhaps the names of witnesses who would be called, and they would decide whether or not, in some kind of story form, to tell what they expect the jury to hear, and then ask very summarily at the conclusion of that, that the jury would find the evidence adequate to prove the case beyond a reasonable doubt. The defense then has the similar opportunity to stand up at the very beginning of the case and give an explanation of what they would expect to prove in their case, either by cross-examination of the state witnesses or by calling the witnesses of their own, including possibly the defendant who may or may not testify. And those choices are typically made later in the trial. However, the defense can also reserve their opening argument or opening statement and until the end of the state's case. There's sometimes a tactical advantage in that the defense can make their arguments more poignant, more pointed, more specific, knowing what strengths or what weaknesses have been shown in the state's case after the evidence is in. So both prosecution and defense have the right to open. The defense has the right to reserve their opening statement if they wish.
And then after that, the evidence is presented by the prosecution. You have witnesses who were called. You know, in the Murdaugh trial, it was a big deal when he took the stand. Everybody, it was a huge, everybody watched, record ratings that he was on the stand, and his testimony went over 2 or 3 days. I mean, it was extended. Do you foresee maybe Lori Vallow taking the stand, and who would make that decision?
Well, ultimately, the defendant makes her own decision about whether to testify upon the advice of counsel. I would expect the defense team would have had many discussions and possible concept and discussions of what they are likely to do or what they may do in this circumstance, what they may do in that circumstance. There's no way to tell whether a defendant will take the stand at this early stage and to predict that. And again, that's a highly closely held defense decision, which perhaps they'll reveal in opening statement, perhaps they won't.
Would having a defendant take the stand really change a juror's mind? I mean, do you think that could be pivotal?
Absolutely, particularly in a he said, she said type of case. It's almost necessary for a defendant to take the stand. In this case, we do know that Lori's team has put in alibi defenses, indicating that in the instance of the homicide of her children, she was not any place where that could have occurred. She was in her own apartment with witnesses who can prove that she was there. In the instance of the other death, she was in Hawaii with witnesses who can prove she was there. That gives her the opportunity to prove her alibi by other witnesses or possibly by taking the stand herself. If she does take the stand herself, of course, she's exposed to cross-examination on not just where she was and those alibis, but every other element of the case. That may be problematic here for her. She may not take the stand.
And the prosecution just in the past few days has issued a response to that alibi saying they have witnesses that can prove otherwise or disprove her alibi, or at least give further information about what that alibi is. So that will be the interesting thing. So you get to the end of the evidence presentation, the end of the witnesses, and right now the trial is scheduled for 10 weeks, but that was when it was going to be Chad and Lori and when death penalty was on the table. I would imagine having Chad removed from the mix, it lessens the time because you don't have another attorney there questioning. And then you have the death penalty removed from the mix, it lessens the time. So, I mean, I guess we're looking at maybe 4 to 5 weeks, all depends. Then you have closing arguments, which I imagine are similar to opening, except you want to really make a splash there, right?
Correct. The prosecution has 2 opportunities for closing statements. The defense only one, because the prosecution has the burden of proof beyond a reasonable doubt. It gets to go first and explain how the evidence that has been put in, the witness testimony, the scientific evidence, the photographs, the documents, everything that they've put in come together to show beyond a reasonable doubt as to each of the charges, each of the elements of each of those charges, and to ask the jury for a verdict of guilty on that basis, retelling their story, reminding the jury of the evidence, and stitching that evidence to each of those criminal charges, each of those elements. A complicated proposition, but also one that can be done in story type form by the prosecutor, highlighting each of the evidence on the way by. Then the defense has the opportunity to talk about how the evidence, as long as it's taken to put in, by virtue of the cross-examination where they've poked holes in it, by virtue of the evidence that the defense has presented, by virtue of the inadequacy of some of the conclusions or arguments that the prosecution is suggesting, that there are reasonable doubts here as to this crime, as to that crime, as to perhaps all of these things that are alleged. And so the defense would cast about for reasonable doubt as to all of these things as they are able, depending on how the evidence has been blocked out or attacked during the defense points of view and the defense case. Then finally, the prosecution gets to once again sum up, poking back at the defense and concluding that the jury should find a guilty verdict on all of these charges because of this, that, and the other thing, the defense's arguments being inadequate. Then the jury would be instructed by the judge, given the law, and reminded how to go forward and present and consider the matters, and hopefully the jury will reach an appropriate verdict on each of the charges.
Sometimes those closing arguments can have memorable phrases like O.J. Simpson, if it doesn't fit, you must acquit. His attorney really drilled that down. And after a 9-month trial, if you're able to get that to stick in the juror's mind, that can make the difference.
Yeah. And I said the judge would instruct the jury after arguments. Typically, a judge instructs the jury before arguments. And so the lawyers can pick up elements of what the judge has instructed and also weave those into their arguments. I stand corrected in that particular.
Thank you for clarifying. So jury comes back with a verdict. Another change now that the death penalty is off the table is before the jury would there'd be this penalty phase, right? And then the jury would decide the sentence, but that's not going to happen anymore.
No, in a non-death penalty case, it's the judge who does the sentencing. Typically, sentencing would be set out sometimes a month or 6 weeks. A pre-sentence investigation report would be prepared for the judge, reviewing the defendant's background and history, reviewing contacts with collateral people on the judge. The things that the judge needs is to consider a proper sentence in the case, contact with family members, mental health history, all of those sorts of things would be produced into a large, thick report given to the judge, given to each of the counsel. And then from that pre-sentence report, the judge would consider a range of options, high and low, the state asking for its recommended sentence, the defense proposing probably something less, and the judge deciding within the elements that he can and within the maximum ranges for each of the crimes upon which there's been a conviction, what the appropriate sentence might be.
It could happen in Fremont County because the judge is going to need some time to get that PSI, the pre-sentence investigation, go through it. And then the sentencing will happen a month to 2 months after the fact. Yes,
I would expect that part of the trial to come back to your neighborhood.
Any other things, David, you think that people need to know about this trial? It's about to kick off?
Well, this will be interesting in a very unique particular. I'm sure it's been done someplace in the country before. But here we, as you mentioned, don't have any cameras in the courtroom. Judge BOISE is showing strong control of avoiding any kind of circus atmosphere in this particular courtroom. And he has said we will give audio recordings either after each session or swiftly after the end of each day, which can be used by the media and by the public to stay informed on what's going on daily in the courtroom. But without those video images, which we're usually associating with high-profile trials, this will look a little different for the people who are interested in the public as you translate for them, because we won't have video, we won't even have still pictures, but we will have the audio, which will put more work on people like you in terms of any kind of broadcast medium.
Yeah, it is definitely different. We also have a sketch artist who has been approved to be in the courtroom, which it's a different visual element than a camera, obviously, but we'll provide all that audio as soon as we get it. So
that will be truly an old-fashioned trial then with the sketch artist, because that's the way things used to be done.
Yeah, it is. David, thank you so much for doing this.